Hello, my name is Vedant. I am a legal intern with LEXIS and Company. In yesterday's video, we discussed what the very important constitutional law concept, that is Doctrine of Eclipse. We discussed and we understand what Doctrine of Eclipse is, on what laws it is applicable, and how Supreme Court will apply while looking at a particular case. So Doctrine of Eclipse is applicable on the pre-constitutional laws, and it makes those laws invalid which are in violation of the fundamental rights after the commencement of the constitution. In this part of the video, we will understand the evolution. We will discuss the evolution of the Doctrine of Eclipse through various case laws as interpreted by the Honorable Supreme Court. So the Doctrine of Eclipse took place through three landmark judgments in the Indian Constitution, namely in three stages. First case was Behram Khurshid Pisikaka versus State of Bombay. This is one of the earliest cases that discussed the reasonable nexus between Article 13 Clause 1 and the pre-constitutional laws. The appellant in this case was an alleged accused under Section 66 Clause B of the Bombay Prohibition Act 1949. Previously, Section 13 Clause B of the same Act was found violative of Article 19 Clause 1 Subclause F and was declared void in FN Balsara case, in FN Balsara versus State of Bombay case. So the appellant contended that the case be taken as a precedent. The court held that the specific part of the provision unconstitutional and void and not the whole law. The second important case was the case of Bikaji Dakras versus State of Madhya Pradesh. The Honorable Supreme Court has very well illustrated the theory of the doctrine in this case that led to its genesis in the post-constitutional era. The factual scenario was that Section 43 of the Motor Vehicle Act 1939 was amended by two pre-constitutional legislation, that is Bearer Motor Vehicles and Central Provisions Amendment Act 1947. So the Doctrine of Eclipse was applied and the case was upheld and unforeseeable. Further, the 1951 Constitutional Amendment in Article 19 Clause 1 Subclause C empowered the state to carry on the business overturn the eclipse to make this provision of the act operative against citizens as well as non-citizens. This effect was questioned, and when the matter reached the Supreme Court, it was held that the impinged law for the time being eclipsed by the fundamental rights. The effect of the amendment was to remove the overshadow and to make the impinged act free from the blemish or infirmity. The third case was Keshav Madhavan Memon versus State of Bombay. This case was discussed under the nature of Article 13 Clause 1 being prospective or retrospective. As far as the facts of the case are concerned, the petitioner was prosecuted under the Indian Press Emergency Powers Act 1931 for publishing a pamphlet without seeking permission, to which he claimed that the provision of the Press Act are in violation of his fundamental right under Article 19 Clause 1 Subclause A. The case was pending during the commencement of the Constitution. The Supreme Court upheld the violation and held that the FR is prima facie prospective in nature. So what were the other landmark cases related to the doctrine? Since the adoption of the Constitution, the Doctrine of Eclipse has developed through various Supreme Court rulings and is still currently applicable to many constitutional cases. One thing to note is that there has always been debate on the validity of Article 368 and eclipse cast on it due to fundamental rights in many cases. The first case is Golaknath versus State of Punjab, in which a petition was filed under Article 32 of the Constitution challenging the Punjab Act 1953 as in violation of the constitutional rights of the petitioner under Article 14 and 19 Clause 1 Subclause F and G. The Supreme Court held that the Parliament does not have the power to curtail the freedom granted under fundamental rights in the Constitution, and any amendment to the fundamental right needs to be constitutional. This decision left Article 368 eclipsed. Secondly, in the case of Shankari Prasad versus Union of India, the Supreme Court elaborately discussed the constitutional validity of the First Amendment in 1951 that curtailed the right to property of citizens. The Supreme Court held that the power to make amendments in the Constitution as per Article 368 are inclusive of power to amend fundamental rights as well. Also, the use of the word law in Article 13 Clause 8 refers to only an ordinary law made in exercise of the legislative powers and not any constitutional amendment that is brought in exercise of the constituent power. Thus, it is implied that a constitutional amendment is deemed valid even if it is against the fundamental rights. It is now settled that even though the parliament of the country is not supreme, it has the power to amend the constitution without changing the basic structure as held in the famous Keshwanand Bharti case. Accordingly, the fundamental rights are also amenable and the eclipse cast on Article 368 is now removed. So, in conclusion, the theory of doctrine of eclipse is of utmost importance in India as it seeks to safeguard the pre-constitutional laws in the country from being completely wiped out from statute books in terms of their applicability. It epitomizes both the rule of law and the theory of constitutionalism. The thin line of difference between the pre and the post-constitutional law is very well balanced by this doctrine to give maximum effect to the provisions and ensure justice. With no compromise on the working of the administrative and legislative wing in the country, the theory prevents wastage of valuable time and resources that may incur in a reenactment of legislations. So this was all about doctrine of eclipse. Thank you.